My name is Brett Burney. I am the e-law evangelist at NextPoint, and I am thrilled to be joined today by Jerry Crawford, who is the principal director at KGC Consulting. Jerry has over 44 years of accumulated experience in the construction industry, for anything from transportation, from energy, commercial, industrial. And we have been having a good time having some discussions with Jerry in his expertise dealing with construction litigation matters and some of the things that we see even at NextPoint here about collecting data, going through email, reviewing it, and producing it. Jerry, it's great to have you here with us today.
Brett, thank you for that, and thank you for that introduction. And yes, in our world, we have to comb through thousands of emails every year, looking at where the conversation started and where the conversation ended. And over that 10 years, we've seen good and bad emails. So today, we'd like to elaborate on some tips that could help the users and people that are watching this video appreciate some standards and some considerations when they're using email.
Many times at NextPoint, Jerry, we talk about the fact that it's pretty amazing sometimes what people will say in an email or type in an email message. Sometimes things they would never say on a telephone conversation or in a face-to-face conversation, but they put it in an email message and it never goes away. There's a lot of times when we can find those emails, and unfortunately, if somebody puts something in there that can be disparaging or that can be kind of an unfortunate mention of something, it could really hurt a litigation case when it comes up. And I think that's exactly what you're talking about. We just wanted to share a little bit today with folks listening about why it's important to even start thinking about this with the people involved in a construction project. Everything from having an email policy, maybe at a company, for example, going through to provide some best tips about what you should be thinking about when you are putting things into an email and into some kind of a communication or a conversation. Let's first start just generally with the importance of an email policy, Jerry. You work with a lot of companies and a lot of law firms and litigators when it comes to this. How do you try to help some of the people you work with understand best why an email policy is so important?
Yes, I like to give the clients I'm working with that the email should have some sort of context, guidance, and reference to the project in hand and other functions, ensuring that correspondence being sent does have some value and includes important information to be expected. It should also address how items should be stored correctly for later reference when it has to be resurrected and revisited.
And even again, from our standpoint, Jerry, that if we have gotten pulled into a litigation matter, we're working with clients, maybe it's a law firm, maybe it's an organization, we need to know where to go to actually collect those email conversations. And it's not just like, where is the email stored? Sometimes it can be about the individuals that were discussing things back and forth, or has email been copied off of the main server in archive somewhere. And that an email policy does a good job of addressing a lot of those components. I mean, even to sometimes, Jerry, we talk about an email policy discusses how long emails are kept in the ordinary course of business, because a lot of times some organizations will get rid of emails after so many days, and they're perfectly fine to do that. But if there's a reasonable anticipation of litigation, they do have that responsibility, that duty at that point to properly preserve that email. And that email policy is one of the first documents that we go to start to understand how best to address that. Can you elaborate just a little bit, Jerry, on maybe some of the contents that go into a good email policy? Give folks just sort of a general understanding of that, please.
Yes, I acknowledge for sure, Brett. There's a big gap with most organizations and companies. They don't have a robust email policy. Some have no policy at all. But an email policy should cover some basics if it's well crafted and drafted. Some formalization of the guidelines to maintain uniformity across teams and external stakeholders is advisable. Issues establishing awareness of privacy considerations or when the use of privilege and confidential should be used if something appears to be litigious that's emerging. Setting up standardized auto signatures and font standards to be employed adds a degree of professionalism. Ensure spelling and the auto correct features are turned on to avoid sloppy spelling. Using important keywords in the subject field and a coded numbering system in the subject line is very useful for filing. And define the use of high important tags and flags, such as is an answer expected in 24 hours if you're going to put a red exclamation mark in there for raising the importance and the awareness. Set up a dedicated project folder and a series of substructure folders for filing key emails such as budget, schedules, NCRs, non-conforming reports. Setting up a dedicated email project folder can be very beneficial if you expect a lot of rotation in the teams. At least everybody's email is getting captured in one consolidated folder. Only use CC high-level executive management if something is extremely urgent or important. And be aware if you have to use privileged and confidential, as I mentioned earlier. And attempt to maintain one subject per email. Do not commingle multiple issues. And this is one of the biggest things we see in litigation challenges, writing subject matter expert reports, is the commingling of multiple issues and multiple subjects on 10, 15, sometimes 20-page string emails where the subject has no bearing in the body of what's being discussed in the content of the email. It's always best to use email, I have found, to conclude a conversation after a telco or Teams meeting. Clarify a time for responding to an email. The policy should also address certain issues in terms of how emails are structured. Bullet points for action can be much more effective than a long paragraph. Be careful with the use of abbreviations with multiple stakeholders, such as California Transportation Commission. If you're going to use CTC, at least spell it out long form first. And the use of the out of office reply with the suggested time you may respond to the email is appropriate if you are out of the office. You have to be aware of cybersecurity policies, identifying the policy as well. If you have an email policy, the blockout periods, like we expect, a response between 8 and 5, but weekends and holidays, and after 5, no, we don't expect a response. And what is the playbook if your email is hacked? Does your organization have that feature? And, document and have an email preservation policy that is being followed. I think you brought it forward, the importance of it. I think you have to task someone to make sure it's being followed.
One of those points that you made, Jerry, which I liked, was setting up different project folders and organizing the email in a certain way. I mean, we all know we get a lot of email messages and we don't always want to take the time to organize those messages. But certainly if you are aware that there is a potential litigation scenario happening, having that better organization is just going to streamline a lot of things. Certainly when it comes to something like what we would do at Next Point, we come in and we need to collect it, for example, so that it can be adequately reviewed and produced. Those are some excellent tips there, Jerry. Thank you. You started going, let's switch gears just a little bit and maybe talk about some best practices to either use or avoid when it comes to the content of emails. And something else I thought of when you were talking about the California Transportation Corporation, I think, or CTC, right? A lot of times we like to abbreviate when it comes to emails. We don't want to type out that whole thing. It is good to do it maybe first. We also find sometimes, Jerry, that people like to use code words, for maybe a construction project or something, right? They may not put the actual formal name, but they may shorten it or abbreviate it, or they may reference a construction site a little bit differently than maybe what we would expect. And I think that's just my little quick tip that I would say, that it would be great if everybody could agree to use the same words, because if we're doing searches on some of those emails, that would be important. But why don't you share with us maybe some other mistakes to avoid, or just some best practices, to be aware of when you're talking about the content of the email?
Yeah. Going back to the abbreviations, certainly engineers, the Army Corps of Engineers, they love the abbreviated acronyms. Definitely something you have to be very careful of in some of these long projects where you have rotating teams and you have different players from different sectors and sometimes different personalities from different countries that may be a bit confused at the outset. But some things to avoid: the thumbs up emoji can be problematic if there's a yes or no decision involving money. It may acknowledge that you're agreeing with something, when in terms you're just acknowledging it. You want to avoid the use of reply all if it's not necessary. A lot of times there's way too much email. People are being copied just for the sake of, hey, well, I told you, right? But they're not expecting any action out of that individual unless things go sideways, and then all of a sudden, hey, you were aware. Never use bold or capital text to make a point. It can appear confrontational. Never discuss private personal matters on company or organization email. A lot of cases have pivoted on some very awkward things that have gone into, describing someone's personality on a project. If you're forwarding email, remove any sensitive or confidential information. If I'm forwarding an email, I always like to strip it down to its lowest common denominator, maybe 3 or 4 strings at most, just so people can follow somewhat the plot. Never start a sensitive email without discussing it first. It's one of the biggest issues I see in litigation. The opening salvo, they did not get off on a good foot. It's better off to make a phone call and say, look, have you got a minute? I think we have a problem. I'd like to discuss it before I put some email together. A lot of relationships sour over getting off on the wrong foot on the first bad email. Never respond to provocative emails when emotionally charged. I think we've all heard that. It's better to respond, not sure I concur. Let me respond more formally when I have time. Is a better way to leave it. You will think differently 2 or 3 days later. And never use language that commits you to something you cannot control.
Very important stuff there, and especially what you were just talking about there. People replying to emails when they are emotionally charged, or I've heard good bits of life advice. It's like, sleep on it, right? Or take an hour to go and think about it first before you just fire off that response. Sometimes I jokingly look at it as, well, that's job security for folks in the discovery industry, because that's where we typically will find some of the most unsavory context of the conversations going back and forth, and that could either be good or bad depending on what side of the litigation that you're on. But we do find, unfortunately, that people just tend to get emotional about it, and they'll fire something off and then they regret what they say, because as I mentioned a little bit earlier, if you put it in an email, it's probably not going to go away. I mean, you may delete an email, but the recipient may have a copy of the email, or there might have been a backup where that email may be. And we are just always cautioning folks that we work with, just be careful what you say in an email and structure it so that it's more in a professional tone. So I very much appreciate the things you just shared there, Jerry. So let's get maybe a little bit more into the legal side of it. Are you aware of any legal cases where emails played a critical role in maybe some of the areas that we have been discussing already today?
Yes, that's a great question. So in research, the Texas Supreme Court decided 2 cases regarding the use of email exchanges to form contracts. The first case, Capano Energy versus Bujanok, and the second was Shocker Energy versus Lenormand Operating. So in the Capano Energy case, they failed the judge, when it went to court, decided that the email failed to contain all the essential terms of the contemplated agreement and therefore was not complete in every material detail, as required to satisfy the statute of frauds. The court further noted that the emails themselves made clear that discussion of the material terms to be included are part of a forward-looking request to negotiate a contract. As a result, the court concluded that the emails did not constitute a written contract that satisfied the statute of frauds. So that's case number one. In case number two, in Shocker Energy, the parties had entered into a confidentiality agreement to enable contract negotiations. That confidentiality agreement stated that no contract would be deemed to exist unless the parties reached a definitive agreement. That court held that the parties' email exchanges contained preliminary agreements in contemplation of a future formalized document and therefore did not meet the requirement for a definitive agreement necessary to form a contract. So the takeaway in this particular set of court cases is this: together, these cases make it clear that an email or series of email can be enforced as a contract under Texas law, but for that to occur, the emails must contain every essential term of the contract. Therefore, must be in writing. A series of arrangements from the court can ascertain every necessary term of the contract. Additionally, both Capano and Chalker suggested that if the parties' emails explicitly contemplate the execution of a formal instrument, that will undermine any future claim that emails themselves are a contract. So I thought that was quite significant that the court had decided the basis of a contract or otherwise on a series of email exchanges. And today, so often, particularly with time and material rush arrangements, quite often parties have very loose email exchanges, and then the debate rages, was it a contract or not a contract?
Yeah, those are always good questions too. And again, I think sometimes, to your point, we think of email a little bit more on the informal side of communication. And here, these cases are just good, Jerry, that you're bringing up here to remind us that a lot of times they could be more formal in the sense of establishing a contract or agreeing to some kind of a situation, or that you agreed to something. I mean, you mentioned the thumbs up, and I think there's even a case out of Canada where it wasn't email, it was actually text messages, and there was a thumbs up that was determined to be an agreement for a contract. I think having some of that awareness, Jerry, is just good, and that's why we appreciate you coming on and giving us some insight into how you can better just not use the email from the content perspective, but I also like the fact that we touched a lot upon maybe the organizational, like the logistics of having an email policy and organizing your email messages so that it can be much easier from a collection standpoint, for example. We just appreciate you sharing your expertise based on your background and experience, Jerry, and thanks for joining us today.
Well, thank you for having me at Next Point. It's always a pleasure.